All right, back at it again. Finishing up the First Amendment, talking about restrictions on speech. So, when is speech restricted? When you are defaming someone's character and when it is obscene. So, defamation of character means you're telling a lie to ruin someone's reputation. And you can do that one of two ways. You can do that through written word, that would be called libel. Or you can do it by speaking, and that would be slander. Thanks to New York Times versus Sullivan, we now have an understanding that if you're a public official, it is much more difficult to prove defamation of character. In this case, a public official must show that there was malicious intent, that somebody actively sought to ruin your reputation through lies. For instance, you see the news article over here, Dick Cheney's a robot. Is that true? No, it definitely is not true. He is not a robot. Is it defamation of character? Is it libel? No, because it's not malicious in intent. It's obvious that this is not real. They are not out to ruin his reputation. Obscenity. This is basically pornography to the extremes. Words, images, or videos that depict sexual activity in an offensive manner and lacks artistic merit. Very difficult to prove when something is actually obscene. It's pretty subjective, and we have the Miller test to kind of help us out here, thanks to the court case Miller versus California. It creates some guidelines here. Something is obscene when it is seen as sexually offensive to the average person, creates an unnatural interest in sex, and is not artistic. It has no artistic merit. Again, this is a very difficult test to prove when something is obscene. However, it has been done, and it continues to be kind of a difficult concept to apply. Hate speech is actually protected speech. This is speech that has no other purpose but to express hatred towards a particular group, either it be racial, gender, or sexual orientation. And while you may not like it, and you may not want to hear it, it is constitutionally protected. It doesn't mean, however, that your hate speech will not have consequences. It just won't have legal consequences. You could get fired if it impacts your workplace, but you're not going to go to jail for it. All right. Finishing up the First Amendment, we got to talk about the right to peacefully assemble. When can you do it? When can't you do it? Well, the courts consider a few things here. They look at the when, the where, and the how. When you protest, where you protest, and how you protest. Always with the consideration of the safety of non-participants, as well as property rights. So public spaces are pretty much fair game, except for schools. You can't just walk out and stop traffic. That is illegal because it could cause harm, right, to non-participants. Now, if you go ahead of time and get a permit to walk the streets, then the city can safely shut down that street and whatnot. So if you're going to have a large protest, you do need a permit. If you're going to have any kind of amplified noise, you're going to need a permit. Private property is off limits unless you have the owner's permission. But sidewalks tend to be the area that a lot of people choose to use when protesting. On the top right corner here, we have the Westboro Baptist Church, and they are protesting at a soldier's funeral, which is what you see over here. And I'll let you read those signs. The Westboro Baptist Church is infamous for their protesting of funerals for soldiers because of their hate towards homosexuals, saying that America is basically going to a very hot place because of its support of the LGBT community. But this is protected speech. The right to peacefully assemble. Even if you don't like what they have to say, they do have the right to do it if it's done in the proper legal manner. Counter-protesting is protected as long as you don't violate someone else's space, and you got to keep it civil. Again, safety of non-participants must be taken into account. All right, let's move on to the Second Amendment here, the right to bear arms. This very controversial subject right now. Thanks to these shootings that have happened more and more frequently, it has been a dividing factor between Democrats and Republicans. So let's start with D.C. versus Heller. The District of Columbia had a ban on handguns, and the question became whether or not the Second Amendment even applies to individuals, or if it only applies to those who are actually connected in a well-regulated, well-armed militia. And the courts determined no, it actually applies to the individual. So you can own a weapon and have it at home for self-defense. The next question became with McDonald versus Chicago. Because District of Columbia is not part of a state, it's actually controlled by the federal government. The question now was, is the Second Amendment protected by the 14th Amendment? Is it incorporated? Chicago maintained their handgun policy, and the courts decided that the 14th Amendment's due process clause does in fact protect the Second Amendment for individuals of states. And so it overturned Chicago's handgun ban and used the incorporation doctrine to extend the Second Amendment to states. The Fourth Amendment deals with illegal search and seizure. So if the police want to search your belongings, they are going to have a warrant with probable cause, and they got to get a warrant from a judge. And that probable cause must show that there's reasonable suspicion of a crime or evidence. When do they not need a warrant? Well, different court cases have kind of rang this in, and there's a lot of other things here too, but the basics, if it's in plain view, if the police pull you over and, oh my goodness, there's your heroin right on the front seat, they don't need a warrant. They can now obtain that as evidence. If the suspect consents to a search, so if they stop your car and they ask if they can look in your trunk and you say yes, well, they don't need a warrant. You said yes. During a legal arrest, if the evidence is in the vicinity or they perform a protective sweep, what that means is, again, if they are arresting you at your home and they are in your living room, if it's in that general area, and if it's in plain view, they can take it as evidence. Or if they are arresting someone and they believe there's another dangerous subject in the area, they can do another wider sweep of the area. And again, if they come across any evidence in plain view, then they can take that evidence. During a traffic stop, so if it pertains to the traffic stop, they can search the vehicle based off of that guideline. Wolf versus Colorado is responsible for incorporating the Fourth Amendment to the states, and Mapp versus Ohio created a very controversial policy or constitutional principle, and that is the one of the exclusionary rule. That means if evidence is obtained improperly, no matter how convincing the evidence is towards your guilt, it cannot be used in a court of law. So if someone murders somebody and the murder weapon is found from that person, but it's obtained illegally, and it shows, like even if you videotaped it and you have complete proof of the guilt of that individual, that evidence cannot be used against them because it was obtained illegally. The exclusion